Hi, my name is Lex and welcome to Lex in Motion. In this video, I'll be sharing with you the last-minute tips for the midterms under Attorney Ben LADIA. These tips are gathered from the many resources circulating around the internet, mostly from his former students. I believe in giving credit where credit is due. Sadly, the copies I have with me do not have the names of the makers of these notes. If you know them, mention them in the comments para naman mapasalamatan natin as a group. Corpo is a very difficult subject to study, especially for us na hindi naman CPA. Many of the concepts are foreign to us and it takes extra time for them to sink in. We need all the help we can honestly get. At dahil walang pasok today, I found the time to record and render these notes for you. Tag a friend in the comments, lalo na yung hirap magbasa at umintindi ng Corpo. Huwag na sanang mag-strike bukas kasi gusto na nating matapos to. Pasensiya na rin at walang drawing kasi gahol tayong lahat sa oras. Before I proceed with the last minute tips, here are a few caveats I'd like to share first. Number 1, may eksaktong hugis ang langit sa mundo ni Attorney LADIA. Meaning hindi daw talaga umuubra ang keywords or phrases sa kanya. Kailangan ng sagot ay kung paano nag-appear sa caudal or sa book niya. 2. Hindi daw umuulit ng exam si Attorney LADIA. Meaning hindi 1:1 ang mga tanong niya from semester to semester. But the general rule is that hindi naman nagkakalayo ang topics. So yung mga gamitin or frequent na topics, study them with extra diligence. 3. Short, simple answers, no more than 4 sentences. Hindi daw niya tsatsagain basahin ang mga mahabang sagot. Answer briefly and concisely. Be responsive and do not discuss matters outside of his question. Come on guys, siya ang sumulat sa libro. Hindi mo na siya kailangang lecturean. 4. Pray for the best possible result. Mahirap ang Corpo pero hindi imposibleng pumasa sa first take. Kapag binagsak mo to, dadagdag ka na naman ng 1 taon sa law school. Gusto mo pa ba talagang bitbitin yung libro niya for another semester? 5. Topics that require special attention are the following: Section 6, Section 21, and Dividends. Founder shares, Treasury shares, and Corporate term. Threefold duties of directors, corporate entity theory, at yung piercing the veil. E.B. Villarosa and the service of summons to corporations, preemptive rights, regular and special meetings, quorum and venue, removal and replacement of directors. God bless us all. Last minute tips for corporation under Attorney LADIA. Number 1, what is a corporation? A corporation is an artificial being created by operation of law, having the right of succession and the powers, attributes, and properties expressly authorized by law or incident to its existence. What are ultra vires acts? Ultra vires acts are acts that cannot be executed or performed by a corporation because these are not within its express, inherent, or implied powers as defined by its charter or articles of incorporation. Ultra vires acts are not necessarily illegal or void. Distinguish a de facto from a de jure corporation. A de jure corporation's existence cannot be attacked directly, while a de facto corporation's existence can be attacked directly in a quo warranto proceeding, which only the state can institute. What are unrestricted retained earnings? Unrestricted retained earnings are the undistributed earnings of a corporation which have not been allocated for any managerial, contractual, or legal purpose and which are free for distribution to the stockholders as dividends. What is a corporation by Estoppel? A corporation by Estoppel is one that is so defectively formed as not to be either a de jure or de facto corporation, but which is considered as a corporation in relation only to those who cannot deny their corporate existence due to their agreement, admission, or conduct. What is the Incorporation Test? The Incorporation Test is applied in determining whether a corporation is domestic or foreign. If it is incorporated in another state, it is a foreign corporation, while if it is registered under Philippine laws, it is deemed a Filipino or domestic corporation, irrespective of the nationality of its stockholders. Define Doctrine of Secondary Meaning. The doctrine of secondary meaning was first applied in Lyceum versus CA. It is a word or phrase originally incapable of exclusive appropriation with reference to an article in the market, because geographically or otherwise descriptive might nevertheless have been used for so long and so exclusively by one producer with reference to his article, that in that trade and to that branch of the purchasing public, the word or phrase has come to mean the article was his product. Define and differentiate authorized capital, subscribed capital, and paid-up capital. Authorized capital is the maximum amount fixed in the articles to be subscribed and paid in or secured to be paid by the subscribers. It is the maximum number of shares that the corporation can issue. Subscribed capital, on the other hand, is the total number of shares and its total value for which there are contracts for their acquisition or subscription. It is the stockholders' equity account, showing that part of the authorized capital stock which has been paid or promised to be paid, or that portion of the authorized capital stock which has been subscribed by the subscribers or stockholders. Paid-up capital is the actual amount or value which has been actually contributed or paid to the corporation in consideration of the subscriptions made thereon. It may either be in cash, property, or in the form of service actually rendered to the corporation. What is outstanding capital stock? It is the total shares of stock issued under binding subscription agreements to subscribers or stockholders, whether or not fully or partially paid, except treasury shares. What are non-par value shares? Non-par value shares are those whose issued price is not stated in the certificate of stock, but which may be fixed in the articles or by the board of directors when so authorized by the articles of incorporation and the bylaws, or in the absence, by the stockholders themselves. What are preferred stocks? Preferred stocks are those that give a holder a preference over the holder of common stocks with respect, 1, to the payment of dividends, 2, with respect to distribution of capital upon liquidation. What is cumulative voting? Cumulative voting is a matter or right granted by law to stockholders in stock corporations to multiply his number of shares to the number of directors. The total number is the total number of votes that he may cast, provided it shall not exceed the number of shares he can vote. What are the differences between cumulative preferred shares versus earned cumulative or dividend credit type? Cumulative preferred shares are those that entitle the owner thereof to payment not only of current dividends but also back dividends not previously paid, whether or not during the past years dividends were declared or paid. It is allowed to receive back dividends for previous years, whether or not they were earned. Earned cumulative or dividend credit type. It gives the holder the right to arrears in dividends if there were profits earned during the previous years, but dividends were not declared. The right to receive dividends is merely postponed. It is only allowed to receive dividends if earned. What are treasury shares? Treasury shares are shares of stock which have been issued and fully paid for, but subsequently reacquired by the issuing corporation by purchase, redemption, donation, or through some other lawful manner. They have no dividend or voting rights, since such is only granted to outstanding shares of stock. Treasury shares may, however, be declared as dividends since they are properties of the corporation. What is the doctrine of limited liability? Under the doctrine of limited liability, the liability of a shareholder is limited by the number of stocks he actually owns. What are preemptive rights and when can they be exercised? Preemptive rights are rights granted by law to all existing stockholders of a stock corporation to subscribe to all issues or dispositions of shares of any class. That is the key phrase, shares of any class, in proportion to their respective stock holdings, subject only to the limitations imposed under Section 39. All stockholders of a stock corporation shall enjoy preemptive right to subscribe to all issues or dispositions of shares of any class in proportion to their respective shareholdings, unless such right is denied by the Articles of Incorporation or an amendment thereto. What is the corporate entity theory? A corporation is a distinct legal entity to be considered as separate and apart from the individual stockholders or members who compose it, and it is not affected by the personal rights, obligations, and transactions of its stockholders or members. Conversely, a corporation has no interest in the individual property of its stockholders unless transferred to the corporation, even in case of a one-man corporation. This was the ruling in Sulo ng Bayan Incorporated versus Gregorio Araneta Incorporated. What is the business judgment rule? Directors are not liable for losses due to imprudence or honest error of judgment. Questions of policy and management are left solely to the honest decision of the board of directors, and the courts are without authority to substitute their judgment against the judgment of the board of directors. What are the distinctions between ordinary and special amendments? An ordinary amendment takes effect upon the approval of the SEC or from the date of filing with the SEC, if not acted upon within 6 months from the date of filing for a cause not attributable to the corporation. On the other hand, a special amendment is subject to the approval of the SEC, and it may be rejected or disapproved on grounds provided for by Section 17. Special amendments are found under Section 37 and 38. Special amendments include 1. An extension or shortening of the corporate term of existence. 2. The increase or decrease in the authorized capital stock. 3. Any increase or decrease of bonded indebtedness. What are the distinctions between a self-dealing and an interlocking director? A self-dealing director is one who deals or transacts business with its own corporation. Such dealings are voidable. On the other hand, an interlocking director is a director who deals or transacts business with another corporation, of which he is also a director. Such dealings are valid, except when there is fraud or the contract is unfair and unreasonable. The material difference between a self-dealing director and an interlocking director is that for an interlocking director, laging merong dalawang corporations. When may directors and or officers be personally liable with the corporation? The personal liability of a corporate director, trustee, or officer, along with the corporation, may validly attach as a rule only when 1. He assents to a patently unlawful act of the corporation, b. for bad faith, gross negligence in directing its affairs, or c. conflict of interest resulting in damages to the corporation, its stockholders, or other persons. The conflict of interest must result in damages. 2. He consents to the issuance of watered stocks, or who, having knowledge thereof, does not forthwith file with the corporate secretary his written objection thereto. 3. He agrees to hold himself personally and solidarily liable with the corporation. Or 4. He is made by specific provision of law to personally answer for his corporate action. What is the test in determining whether a corporation has the implied power to do a certain act? 1. Direct and immediate furtherance of the corporation's business. 2. Fairly incident to the express powers. 3. Reasonably necessary to their exercise. What is the limitation imposed by law on the right of a corporation to decrease its capital stock? A corporation is free to decrease its authorized capital stock, but it must not prejudice third persons and creditors. What is the business judgment rule? The business judgment rule provides that directors are not liable for losses due to imprudence or honest error of judgment. Questions of policy and management are left solely to the honest decision of the board of directors, and the courts are without authority to substitute their judgment against the decision of the Board of Directors. What are the limitations of the bylaws of a corporation? 1. The bylaws must not be contrary to law, public policy, or morals. 2. It must not be inconsistent with the Articles of Incorporation. 3. It must be general and uniform in its effect or applicable to all alike or those similarly situated. 4. It must not impair obligations and contracts or vested rights. 5. It must be reasonable. What are the advantages of the corporate form of business? First meeting pa niya diniscuss to, but it is entirely possible na itatanong niya. The advantages of the corporate form of business are 1. Capacity to act as a single unit. 2. Limited shareholders' liability. 3. Continuity in existence. 4. Feasibility of greater undertaking. 5. Transferability of shares. 6. Centralized management. 7. Standardized method of organization, management, and finance. What are the requirements for the amendments of Articles of Incorporation? 1. There must be a resolution by at least a majority of the Board of Directors or Trustees. 2. Vote or written assent of the stockholders representing at least 2/3 of the outstanding capital stock or 2/3 of the members in case of a non-stock corporation. 3. Submission and filing of the amendments with the SEC as follows. 1. The original and amended articles together shall contain all the provisions required by law to be set out in the Articles of Incorporation. Such articles as amended shall be indicated by underscoring the change or changes made. 2. A copy thereof, duly certified under oath by the corporate secretary and a majority of the directors or trustees, stating the fact that such amendments have been duly approved by the required vote of the stockholders or members. C. Favorable recommendation of the appropriate government agency concerned in the case where the corporation is under its supervision. What are the two methods for the enactment of corporate bylaws? The law requires that the bylaws of a corporation must not be inconsistent with the code. If they are adopted prior to incorporation, the law requires that they must be approved and signed by all the incorporators. They are submitted together with the Articles of Incorporation to the SEC. If they are adopted subsequent to incorporation, first they must be adopted within 1 month after receipt of official notice of the issuance of the Certificate of Incorporation given by the SEC. 2. The affirmative vote of the stockholders representing at least a majority of the outstanding capital stock or of at least a majority of the members in case of non-stock corporations. C. Signed by the stockholders or members voting for them. D. Kept in the principal office of the corporation, subject to the inspection of the stockholders or members during office hours. A copy thereof duly certified to by a majority of the directors or trustees, countersigned by the secretary of the corporation, must be filed with the SEC, which shall be attached to the original Articles of Incorporation. Under both methods of adopting the bylaws of a corporation, the certification from the appropriate government agency concerned to the effect that such bylaws or amendments are in accordance with law is necessary. Another requirement is the issuance by the SEC of a certification that the bylaws are not inconsistent with the corporation code. What are the disadvantages of the corporate form of business? First, to have a valid and binding corporate act, formal proceedings such as board meetings are required. 2. The business transactions of a corporation is limited to the state of its incorporation and may not act as such corporation in other jurisdictions unless it has obtained a license or authority from the foreign state. 3. The shareholders' limited liability tends to limit the credit available to the corporation as a separate legal entity. 4. By the very nature of shares of stock, which are personal properties transferable at will by the owners thereof, transfers of share may result to uniting incompatible and conflicting interests. 5. The minority shareholders have practically no say in the conduct of corporate affairs. 6. In large-scale enterprises, stockholders' voting rights may become merely fictitious and theoretical because of disinterest in management, wide-scale ownership, and inaccessible place of meeting. 7. Double taxation may be imposed on corporate income. 8. Corporations are subject to governmental regulations, supervision, and control, including submission of reportorial requirements, not otherwise imposed in other forms of business. What is the test in determining whether a corporation is private or public corporation? The test in determining whether a corporation is private or public is found under the law creating it. If a corporation is created by virtue of the corporation code, then it is a private corporation. If a corporation is created by a special law or an act of Congress, then it is a public corporation. Enumerate the instrumentality test. First, control, not mere majority or complete stock control, but complete domination, not only of finances, but of policy and business practice in respect to the transaction attacked, so that the corporate entity had at the time no separate mind, will, or existence of its own. 2. Such control must have been used by the defendant to commit fraud or wrong, to perpetuate the violation of a statutory or other positive legal duty, or dishonest and unjust act in contravention of the plaintiff's legal rights. And 3. The aforesaid control and breach of duty must be the proximate cause of the injury or unjust loss complained of. What can be consideration for stocks? Consideration for the issuance of stock may be any or a combination of any two or more of the following. 1. Actual cash paid to the corporation. 2. Property, tangible or intangible, actually received by the corporation and necessary or convenient for its use and lawful purposes at a fair valuation equal to the par or issued value of the stock issued. 3. Labor performed or services actually rendered to the corporation. 4. Previously incurred indebtedness by the corporation. 5. Amounts transferred from unrestricted retained earnings to stated capital. 6. Outstanding shares in exchange for stocks in the event of reclassification or conversion. When can non-voting shares participate in voting? As a general rule, non-voting shares cannot vote. The exceptions are found under Section 6 of the Corporation Code. 1. Amendment of the Articles of Incorporation. 2. Adoption and amendment of bylaws. 3. Sale, lease, exchange, mortgage, pledge, or other disposition of all or substantially all of the corporate property. 4. Incurring, creating, or increasing bonded indebtedness. 5. Increase or decrease of capital stock. 6. Merger or consolidation of the corporation with another corporation or other corporations. 7. Investment of corporate funds in another corporation or business in accordance with this code. And 8. Dissolution of the corporation. What are the rules on dividends? Dividends as a general rule may only be issued at the sound discretion of the board of directors. The exception is that stockholders may compel the board of directors to declare dividends if the unrestricted retained earnings of the corporation exceed 100% of the authorized capital stock. The exception to this rule is the shares of stock denominated as mandatory if earned. If the shares fall under this classification, the board of directors really have no choice but to declare dividends with respect to the shares denominated as such. Marami nang nahuli si Atty. LADIA sa tanong na yan. Next, let's talk about modes of increasing capital stock. Capital stock may be increased in 3 ways. First, by increasing the par value of the existing number of shares without increasing the number of shares. 2. Increasing the number of existing shares without increasing the par value thereof. Third, increasing the number of shares and at the same time increasing their par value. What are the 3 kinds of dividends? Dividends may be classified as 1. Cash dividends, 2. Property dividends, 3. Stock dividends. Property and cash dividends have the effect of decreasing the net worth of a corporation. A stock dividend, on the other hand, does not decrease the net worth of a corporation. They come from the portion of the authorized capital stock not yet issued. The net effect is that the authorized capital stock is divided into smaller pieces, the shares issued as stock dividends. The consent of the stockholders is necessary because it is a derogation of the reason why stockholders subscribe to a corporation. People invest in a corporation because they want to earn money from it. If the corporation instead declares stock dividends, they do not see a return of their investment. Rather, it is only their interest in the corporation that increases, but not the money in their pockets.